everybody. Welcome. It's really nice to be here in person. It's been a while. And I want to just acknowledge that this is great, and also great that people are joining us virtually. But it is my pleasure to introduce you to our presenter. This is the second in our 4-part Environmental Justice and Democracy series. And I am delighted that we have Mia Montoya Hammersley here with us. Mia serves as the director of the Environmental Justice Clinic at Vermont Law School and Graduate School, and also as assistant professor of law there, and is doing really interesting work to support communities that have been dealing with issues that she's going to be talking about tonight in terms of protecting land and vital resources from extractive industries. So I want to share with you that Mia is a member of the Piro-Manso-Tiwa Indian tribe, the Pueblo of San Juan de Guadalupe, and a Yome and Yaqui descendant. And in her work, she has represented conservation organizations focusing on land and extractive industries, tribes in defending their water and land rights, and communities experiencing disproportionate environmental health harms. She writes that she strives to ground her practice in the tradition of decolonial community and movement lawyering. And in addition to having a JD with not one, but 2 certificates, one in Indigenous peoples law and policy, and the other in environmental law, science, and policy, Mia did a master's of science in water policy before going to law school from the University of Arizona. In 2021, she was recognized by Black Millennials for Flint for her work in the field of environmental justice. She was recognized as one of the young, gifted, and green 40 under 40 somethings. And she has a forthcoming article that is coming from University of Memphis Law Review entitled In Defense of Land and Water Protectors, Environmental Justice and the Criminalization of Environmental Activism. The presentation this evening draws on a lot of that work. So it is my pleasure to welcome her to the podium. And Mia, thank you very much for being here with us.
Thank you so much for that very warm welcome. I'm so pleased to be spending my evening with you all tonight, and like I was saying, excited to be engaging and hopefully having a great discussion afterward with community academics. You know, I spent a lot of time in the legal community, and I was really enjoying some of the discussions that we were having over dinner this evening. So before I dive into some of the substance of my talk, I wanted to start by spending a little bit more time introducing you all so that you can get to know me a little bit better and understand some of my background and reasons for coming to this work, because it really informs, you know, my practice as a lawyer and also as a scholar, and how I approach some of the issues that I'm going to be talking about this evening. So, has anyone been to the White Sands, New Mexico? Oh, that's great. I love that there's a few folks who have been back in person. So, for those who haven't been, White Sands is Young National Park located in southern New Mexico. It is a part of my tribe's ancestral territories. And in 2022, I was actually lucky enough to get the opportunity to participate in a tribal site visit to a newly discovered archaeological site in the White Sands, where archaeologists discovered what we now know to be the oldest discovered human footprints in North America. So these are dated to about 23,000 years old, and these are the footprints of some of my ancestors. And this is how long that my people have been in this area. And just to give some context to that time period, these footprints were found alongside mammoth footprints and great sloth footprints, and it was in an area that was once a large body of water, and the mud enabled the preservation of some of these footprints. And it was a deeply impactful experience for me. There were also footprints from children running, playing in the water, and it's just a really incredibly preserved site. So I always begin many of my talks by talking about where I'm from, my community, because like I said, my work is, that's what really grounds me in the work that I do. So the other part of my story, why I begin with the white sands, is because I come from a community of downwinders, people that were impacted by the nuclear fallout from the Trinity nuclear test. So many people actually don't know about this particular piece of United States history, don't know that the first nuclear bomb to ever be detonated was actually in Mexico. So this Trinity, and perhaps some of you in the audience have seen Oppenheimer, the movie, which explored some of these themes, although, you know, conveniently left out in the mention of my community or some of those consequences, but Trinity was the code name of the first detonation of a nuclear weapon in the world conducted by the United States Army on July 16, 1945, as part of the Manhattan Project. This test was of an implosion design plutonium bombs, which was the same design of the bomb later detonated over Nagasaki. So it detonated 25 kilotons of dynamite. It's really hard to visualize or understand like the magnitude of an explosion of that size. Created a mushroom cloud that was over 38,000 feet high. To this day, it's the dirtiest, most polluting nuclear bomb that was ever detonated. At the time of the detonation, scientists weren't actually sure what was going to happen. You know, this is very much an experiment, but an important thing to know that I always like to inform people of is that there were 500,000 people within 150 miles of the blast zone when this took place. Nobody was informed ahead of time that this test was going to be taking place, and my family, where they're from in Tularosa, is about 62 miles by car, 45 miles as the crow flies from the site of the detonation. My grandparents were children. This bomb was detonated. There's a lot of oral history in my community of children in summer camp in the mountains. Again, this happened in July. So there's stories of people assuming that it was, an unseasonal snowfall going out and kids playing in the nuclear radiation. My community is extremely rural. Everyone was growing their own food, collecting water in cisterns. The nuclear radiation blanketed all of these natural resources. So again, I speak about this a lot, but it still is emotional sometimes. But Oppenheimer is going to have spoken these words from the blogger Pizza when the bomb was detonated, which is now have become Death, the Destroyer of Worlds. So I tell this story because we've lost many people in my community to cancer, but it's also what kind of brought me into the world of activism in many ways. And as I grew up and started to contextualize and understand my community story in the broader context of systemic injustice and environmental justice, I started to understand that what my community had experienced was, inherently interconnected to the environmental injustice that other communities were also experiencing. So, Tularosa continues to be a cancer hotspot. My family lost my grandfather to pancreatic cancer when I was a teenager, and every year on the anniversary of the Trinity test, the community gathers to vigil in remembrance of all of the community members who have passed away from cancer. So this is a big part of my personal story, my family's history, my understanding of environmental justice, and also my introduction to environmental activism as well. I wanted to start with a couple definitions to get us on the same page. Many of you have probably studied environmental justice or engaged in this work in a variety of ways. I always like to share Dr. Fuller's definition, which is that environmental justice embraces the principle that all people and communities are entitled to equal protection of our environmental laws, housing, transportation, energy, food, and water security and health laws, environmental justice is nothing more than the principle people have the right to a clean, healthy, sustainable environment without regard to race, color, and national origin. The EPA definition tends to focus, well, the latest EPA definition focuses more on procedural justice, right? So ensuring that people have equal opportunity to have meaningful involvement in decision making that affects their lives. And then I also teach environmental justice to my students in the context of the distribution of environmental costs and benefits, right? Which communities are being asked to be sacrificed them to take on some of these costs of extractive industries, of mining, of petrochemical infrastructure, so that the rest of us can benefit, right, from that resource extraction. Who is valued in society and who's not valued, right, which is connected to larger systems of inequality. And then environmental justice is, we can't have a discussion about environmental justice without discussing environmental racism, which, like other forms of racism, is systemic in nature and intersectional. So I want to talk about some of the roots of the environmental justice movement. So the environmental justice movement officially began on the heels of the civil rights movement. And this landmark report in 1987 is largely credited as the official start of the movement, and this was published by the United Church of Christ Commission for Racial Justice. It's a report called Toxic Waste and Race in the United States. And this is the first report that revealed the relationship between the treatment and storage of hazardous waste and race. So this report was published by this church that was largely active in the civil rights movement, but this was the first time that they shifted to this sort of research-based advocacy. And then to this day, race is still the largest indicator of whether or not you live close to a hazardous waste facility. 5 years after this report was published, the first National People of Color Environmentalist Leadership Summit was held in Washington, D.C. And this was a summit where delegates from across different movements, labor rights, environmental activists, civil rights movement activists, met together to adopt the principles of environmental justice here that continue to guide the EJ movement to this day. So in teaching environmental justice and practicing environmental justice, I am constantly coming back to these principles to guide the work, but of course, they're not just applicable to lawyers, they're applicable to anyone who's moving and practicing and showing up in the space. Another important part of environmental justice history that also stems actually from history in New Mexico is the sending of the Southwest Organizing Project, or SWAP, this letter from environmental activists, people of color, all people of color from different swaths of the movement, including artists, labor rights activists, essentially calling out a group of what was then known as the Big Ten. So the larger environmental nonprofits at the time, including Sierra Club, Earth Justice, basically calling them out on the exclusion of people of color from the mainstream environmental movements. So notably, that letter expressed that these organizations have kind of continued to support and promote policies that emphasize cleanup and preservation of wilderness areas, rather than the protection of working class people and people of color in particular. And I also teach federal Indian law, so I always like to point out the ways in which the concept of wilderness is very much rooted in Indigenous erasure, right? The idea that wilderness areas were empty before we got here, and places that are separate from people and from us. While improvements have definitely been made in the 30 years since this letter was sent, as of 2023, 71% of senior staff, 68.4% of heads of organizations, and 56.2% of board members at environmental organizations are white. So we still have a lot of work to do to ensure that our movement spaces, our advocacy spaces are representative of all of the people that we are serving. Another function of environmental racism you see here is procedural. So there are many ways that our laws function to disenfranchise communities from meaningfully participating in decision-making processes that impact their lives and their health. As a environmental justice lawyer, I deal a lot with this aspect of procedural justice, trying to ensure that my clients are able to have, for example, language access. Just to give you an example of some of the common barriers to public participation. For example, perhaps there's a polluting facility that primarily impacts a primarily Spanish speaking community. Depending on the laws in that state and what kind of protections are in place, there may not be adequate requirements that notices that go out to the community are provided in Spanish. There may not be adequate requirements that notices about public hearings, for example, or comment periods are sent out with enough advance notice that working class people are able to take time off of work to then attend meetings. Oftentimes, public notice requirements can be fulfilled by, for example, posting this is definitely not speaking from personal experience here, but can be satisfied by posting a tiny little notice in a very obscure newspaper that nobody in the community actually reads, right, in a language that most of the people in the community don't actually speak. So procedural justice is often finding ways to get at those requirements and trying to ensure that state regulations and public participation laws adequately provide those protections and ensure that people are actually able to be involved in those decision-making processes. So we chatted about this earlier, actually, but I'd also like to include the famous principles for democratic organizing, which were co-created at the working group meeting on globalization and trade in New Mexico in 1996, which was hosted by the Southwest Network and Economic Justice. So the famous principles are not specific to the environmental justice context, but are principles that I teach in my clinic work, and I think again are largely applicable in a lot of different movement work and helpful to come back to. So when you all think about lawyers, what are some of the common stereotypes that maybe come up? Everyone's like, if you think about some of the common shows about lawyers, you often think about lawyers as aggressive, having a relationship with their clients where the lawyer is swooping in and has all the answers and saving the day, right? Very much like main character energy. So in my practice, in my clinic, I introduce my students to this alternative framework for lawyering known as community lawyering, or alternatively movement lawyering as well, which is kind of an antidote to a lot of the issues that I think come up in movement spaces when lawyers are trying to navigate movement spaces. And we know, you all know from your research and your experience too, that you can't just swoop into a community and say, I'm the expert, I know what's best for you, I have all the answers. Lawyers love to do that, but so community lawyering offers an antidote to some of those cultural norms, I think, in the legal profession. So rather than centering the lawyer, community lawyering asks us to center frontline communities and accepts that those who are most affected by issues are the experts of their own experiences, right, and are in the best position to come up with solutions. It places lawyers in the context of bigger systems, right, and understands that we are just, I also tell my students, lawyers are just people with a particular set of skills, like anyone else, right? We all have our skill set that we're contributing to movement work and to change. It values relational or power theory, or values relational power or power theory rather than power hoarding, which is also common in a lot of traditional lawyer-client relationships where the lawyer has all of the knowledge, knows what's going on, has that specialized information to understand the legal system, and isn't necessarily involving clients or communities as an equal partner or decision maker. It also approaches community identified problems as opportunities to engage stakeholders in broader conversations in the hope of building authentic, trusting relationships. Community lawyering to me is all about relationship building. It often takes time, right, to build true relationships with community members. Many of the communities that I work with really have suffered from, I think, kind of a common situation with many environmental justice communities where a lot of people, researchers and lawyers and organizations tend to kind of come in and out, all with good intentions, but at the end of the day, it's can be hurtful to them to know that they don't have the option to come in and out. This is their life and their community, and they want to build partnerships with people who are going to value longevity, right, and not interact with them in an extractive way and then leave. It also places attorneys as supportive players rather than main characters, and then seeks to help organizations like basically applying our skill set to assist communities in building their own organizational capacity and helping empower them to make changes that they see fit in their community as well. So I love this quote by Professor Betty Khan, who defines movement lawyering as lawyering that supports and advances social movements, defined as the building and exercise of collective power led by the most directly impacted to achieve systemic, institutional, and cultural change. So what does all of this have to do with activism and criminalization of justice activism? Movement lawyering, like I said, values a lot of different skill sets, right? And recognizes that change is not a unilateral function, right? It takes a lot of different people with different skill sets all working towards a goal and a movement in order to move things forward. That includes activism, right? If we're looking at building holistic movements, some of these concerning trends involving increasing penalties and increasing criminalization of environmental activism is something that all of us should be concerned about, right? And that because activism and also civil disobedience plays an important role in our movement work in the environmental justice space. A few of these concerning trends that I want to highlight before we get into some of the law around this. So in 2015, there was a report by the United Nations Special Rapporteur on the rights to freedom of peaceful assembly and association that reported that environmental activists face considerable opposition, harassment, stigmatization, and even physical attacks from state and non-state actors in many countries. Here in the United States, we see a lot of concerning trends around penalty enhancements for civil disobedience in the environmental activism space, retaliatory targeting by prosecutors with political motives, racial disparities in the treatment of different people navigating the criminal system, and then laws being passed more and more that specifically target civil disobedience. For example, critical infrastructure acts, which we will discuss a little bit later. So a couple of examples of this that I wanted to walk us through, some that I have personal experience in and some that I don't. I was a second year law student here that the uprising in Standing Rock occurred, so I was not able to get myself from Arizona to up to the Dakotas, but it is forever a regret of mine that I couldn't figure out how to make that work. So many of you are probably familiar with what Standing Rock at this point. The water protectors gathered at Standing Rock to oppose the construction of the Dakota Access Pipeline, a project that was slated to move 500,000 barrels of oil a day under the nearby Missouri River. So the tribe was rightfully concerned that this infrastructure was going to threaten its main water supply and also destroy several sacred ancestral sites. So in months, thousands of protesters from around the world joined a camp near the river, which united a lot of different actors here. There were conservative farmers, urban environmentalists, and members from hundreds of tribes from across the country. And to this day, this has become the largest Indigenous resistance effort in United States history. So here, water protectors were brutalized by police who used riot gear, militarized equipment, and deployed water cannons in freezing temperatures, rubber bullets, and tear gas to disperse crowds. And even after the camps were dispersed, water protectors were targeted with heavy and targeted charges, including felony charges. So these pictures are from my time, one of the pipeline resistance camps in what is now called Minnesota and treaty territory. I was able to make it up there just the week after the pipeline the construction was completed under the stretch of river that you're seeing here on these pictures. So line 3 protests intensified around 2020 to 2021 were aimed at halting the replacement and expansion of the Line 3 crude oil pipeline in northern Minnesota. So opponents included Indigenous activists, environmentalists, and local communities who were concerned that the project would threaten water resources, degrading and exacerbate climate change. It's not the time to be expanding and continue to invest in fossil fuel infrastructure, yet I digress. So the protests really inspired by the uprising expanding included large encampments, direct action, legal challenges, employing a wide variety of tactics and groups to address this issue, highlighting issues of Indigenous sovereignty and environmental justice. But despite significant public outcry and a wide variety of activist efforts, the pipeline was completed in late 2021. The pipeline crosses the Mississippi River 3 times, and there have already been multiple spills since it was completed. During my time at Line 3, we faced a pretty constant threat of police raids of the camp, also a lot of harassment by local community members who were not thrilled by the large influx of activists and water protectors to the area. Here as well, water protectors faced a lot of arbitrary charges. For example, one of the most egregious examples that I found of this was an instance where water protectors had locked themselves inside the empty pipeline to avoid another strip of pipeline from being completed. They were charged with felony attempted assisted suicide for locking themselves inside the pipeline, which is a law that, in the legal context, you often look to what did the legislature intend to be the purpose of this law. You can imagine that this type of civil disobedience probably wasn't what the legislature had in mind when they created this law. So you can see how those types of charges are really used to send a message to activists and water protectors, and to discourage civil disobedience and to discourage protests and activism in general. For Line 3, documents also reveal that law enforcement agencies received support and resources from the pipeline company on bridge, including training and intelligence sharing to monitor and manage protests. Again, this relationship raises a lot of concerns about the militarization of police response to peaceful protests and implications for civil rights and environmental justice. The last kind of short case study I wanted to highlight is another issue that probably many of you are familiar with at this point, which is the Cop City protests, which emerged in Atlanta, Georgia. These protests and this movement was sparked by plans to construct a large police training facility, officially called the Atlanta Public Safety Training Center, referred to as Cop City. And this police training center would be complete with a completely mock city center where police could engage in realistic training scenarios. There's also all of this interesting intersectionality with the film industry actually happening in this area, because the mock city can also be used for certain filming opportunities. Atlanta is already a community that experiences a lot of impacts from over policing, and the Milani Forest, where Cop City is proposed to be built. It's also the largest green space in the Atlanta metropolitan area that a lot of communities rely on to be in relationship with the natural world, and also a really important watershed in this area as well. And before it was a state forest, it was a prison camp, and then actually originally land that the indigenous people were removed from as well. So in 2023, Portuguita, Manuel Esteban Terán was shot and killed by police during a raid of the Cop City encampment. So you can see another extremely egregious example of police brutality against environmental activists. Before I get into critical infrastructure, I just want to make another note about what these protest spaces are like. I think sometimes when I talk about this subject, people are a little resistant to the idea of civil disobedience and resistant to the idea of property damage being categorized as civil disobedience, which I generally do include this type of property damage against corporate interests where there's no intention for anyone to be harmed within the umbrella of civil disobedience. But I just like to paint a picture for people about what it's like to be in some of these encampment spaces, right? And why we should be supportive and not afraid as well. I think a lot of people are scared about the idea of intentional law breaking with activities for our own security and safety, and I understand that concern as well, but I can say during my time at the Line 3 encampment, we were waking up every morning. The Indigenous women would go sing a song in the morning to the river before we started the day. We were all cooking for each other. We had a whole schedule around who was cooking, who was doing dishes, who was in charge of security at the front of the camp to make sure that people could be warned of any impending police raids or other threats to the safety of water protectors on site. Similarly, when I was able to travel to Atlanta to be part of the Cop City Legal Action in 2023, just several months after Portuguita was killed by police, a couple days after a music festival in the forest was raided by police as well. Again, this was a space where people were feeding whoever needed to be fed, where there were music circles and tree planting activities, like very much a group of people who have left their homes and their jobs and their families for whatever period of time they're able to make that work because they believe so much in this cause or in stopping what's happening, or cannot stop what's happening, being there to bear witness to that injustice and to bear witness in community with other people. And that is extremely valuable in itself. And seeing some of the sacrifices, I'm definitely one of those people who, again, I can kind of choose to go to the front lines when I'm able to, but I'm not living my whole life there. That's also a privilege. Seeing people who spend more time putting their lives, livelihood, bodily safety on the line to engage in civil disobedience, particularly against the expansion of pipeline infrastructure. They're really doing that for all of us, right? And there's a role for that in our society. Coming out of Standing Rock, you start to see the rise of these what we call critical infrastructure laws and heightened penalties for protesting near a pipeline. So these laws have largely been supported by the fossil fuel industry, which should shock me, but notably, many of these bills resemble a model critical infrastructure bill circulated to state lawmakers by the American Legislative Exchange Council, also known as ALEC, for those who are familiar with their particular work. So in general, these laws enhance penalties for protesting near oil and gas pipelines. expand the scope of what constitutes a critical infrastructure facility, right? To create a broader scope of a potential for prosecution, and establishes organizational and criminal liability. These laws generally target both protected speech and assembly, like protests, as well as non-violent civil disobedience actions intended to impede pipeline construction. So, for example, you can see here South Dakota or North Dakota passed a critical infrastructure bill in 2019, which was just 2 years after water protectors gathered to oppose the Dakota Access Pipeline. This law in particular prohibits, and it's to quote, interfering, inhibiting, impeding, or preventing the construction or repair of a critical infrastructure facility, and violations are categorized as a class of felony, punishable by 5 years imprisonment, which was a very severe punishment for this type of violation, which 5 years imprisonment or a fine of $10,000. And in addition, organizations that have been found to have conspired with the violator may also be held criminally liable for up to $100,000, right? So if you can imagine you are a small nonprofit trying to get involved in advocacy or pushing back against pipeline infrastructure, this is also becoming a deterrent, right? Do you have that money to protect yourself in case of a lawsuit or a slap suit, right? Which is often a strategy that these large corporations can engage in order to limit and discourage and basically scare people away from challenging them. So many of these laws also enhance penalties from misdemeanors to felonies for your kind of run-of-the-mill trespass charges, and suddenly these things are punishable with years of jail time, which ultimately sends a clear message of deterrence to activists and organizations opposing pipeline infrastructure in the post-Sandy. So I'll get into a little bit of law here, and that's all, but I'll do. So most of you are probably familiar with the First Amendment, which says that Congress shall make no law respecting the establishment of religion or prohibiting the free exercise thereof or abridging the freedom of speech or the press. In his famous letter from a Birmingham jail, Dr. Martin Luther King offered this framework for nonviolent civil disobedience, which is that one who breaks an unjust law must do so openly, lovingly, and with a willingness to accept the penalty. I submit that an individual who breaks a law that conscience tells him is unjust and who willingly accepts the penalty of imprisonment in order to arouse the conscience of the community over its injustice is in reality expressing the highest respect for the law, right? So this model of civil disobedience, where the point of civil disobedience and the goal is to move the hearts and minds of people to inspire change in other areas of our democracy, perhaps inspiring different voting decisions or advocacy in non-law breaking capacities. This model is often associated with Dr. King and Mahatma Gandhi, although I always remind people too that civil disobedience is deeply rooted in Indigenous resistance as well. For example, if Indigenous people had not been engaged in the secret law breaking against laws that prohibited certain cultural practices, ceremonies, many of us in our communities would not exist today in the same way that we do, because people were breaking those unjust laws and practicing their culture, practicing their religion, sometimes in the dead of night, not out in the open in the same way that you see in the civil rights movements, but also always like to just recognize the Indigenous roots of civil disobedience as well. So while not all theorists align with this aspiration for kind of like a sportsmanship type of civil disobedience, right, that you're actually expressing respect for the law and that you have to accept the consequence, and that's part of your practice of civil disobedience, I think we really have to ask whether this directive remains sustainable for activists in the face of increasingly severe and at times unpredictable punishments and legal consequences, right? Can we ask people to accept whatever consequences come if those consequences may be, a felony charge that changes the course course and trajectory of your life, or extreme bodily harm or even death because of police brutality. So I will end by arguing that there is an important place for civil disobedience in our democracy, and that it's distinct from other forms of criminality in its recognition of the limitations of lawbreaking to further movement goals, and ultimately does signal respect for the democratic process. Civil disobedience is inherently and defiantly hopeful act. It's a belief that the power of sacrifice or of collective sacrifices often can move the hearts and minds of people to push for incremental changes towards justice. It's also a belief that breaking the law delivers a more powerful impact at times, or in conjunction with lawful means of activism, right? Civil disobedience is hardly ever occurring in a vacuum. It's again, if we go back to concepts of movement lawyering, community lawyering, movement work in general, it's often happening in conjunction with many other people, with many other skill sets, working together towards that goal. In the context of environmental activism, the laws that are broken are often state laws against trespass or disorderly conduct, but may also lead to state liability or fall under federal criminal prosecution. So in the environmental context, the protest often lies in not necessarily breaking a law that is unjust, like the bus boycotts, but in breaking a law in furtherance of a movement's goal to bring attention to an injustice or to slow or interfere with an unjust extractive project. So there is one limitation, there's one more legal concept that I wanted to introduce you all to. So there's this important case called United States versus O'Brien, where the Supreme Court essentially outlines how to determine whether or not laws that target conduct, but incidentally also impact expression, are constitutional. So basically, a law like laws that target pipeline protests, for example, would be constitutional if it's within the constitutional power of the government, it furthers an important or substantial government interest. For an example of some of these critical infrastructure acts, the government might argue that its interest there is public safety, which is a really common governmental interest that they fall back on to defend this type of legislation. The government interest is unrelated to the suppression of free expression. So they're saying we're just protecting people. We don't want people getting close to this infrastructure because it's dangerous. We're not trying to target their speech or their activism or their protests. We're just actually really concerned about safety. Right? And then the incidental restriction on alleged First Amendment freedoms is no greater than is essential to the furtherance of that interest, right? So the law is limited enough that it's accomplishing the goals without being too excessive, right? So you can kind of see how the legal framework that we have today makes it really challenging to challenging to address some of these laws, right? Because it's government has clever lawyers who are great at making good arguments about the important governmental interests that's covered by a lot of these laws. So I will end with just introducing this concept that other legal scholars have also argued for, which is that I believe and argue, and other scholars have also argued, that even though civil disobedience is not covered because it is law breaking, it is not included in protections provided by the First Amendment. It should still the First Amendment should still offer some protections for civil disobedience because it has such an expressive purpose, right? And often it's really tricky to pick apart civil disobedience versus protests versus protected speech because these things are often happening all together. I think it can often be really challenging for courts to kind of pick these things apart. And furthermore, the First Amendment does kind of provide this penumbra of protections. And because of the ways that civil disobedience actions are distinct from other criminal actions, some scholars have made an argument that there should be a First Amendment carve out for civil disobedience that would kind of stay the hand of justice, right? That would prevent such harsh penalties in the interests of recognizing the expressive intent of civil disobedience. So I will leave you with this because I know people are always like, this is really depressing. What can I do? Don't want to leave you depressed. I always tell my students, I'm like, things are hard, but I think in this area of law, it's important to reframe what our definition of success, right? I think we don't often have big splashy wins in environmental justice law, but if we restructure our wins to look at the relationships that we build, being able to show up when it matters, those are the things that I try and define as wins for me and for my students, and that keeps me going. So things that you can do even without being a lawyer, you can show up to protests. You don't have to break the law. I'm not telling you to break the law. You don't break the law unless you have a lawyer and a plan. You know, take a know your rights training. You can also volunteer to be a legal observer at a protest. There are great trainings hosted by the National Lawyers Guild for this. You can also volunteer to be a street medic if you have any kind of like medical background or interests. Donating supplies and supporting your local mutual aid organizations, donating to your local bail funds. And then I'm also a board member at the Water Protector Legal Collective as well, which is an amazing organization founded by the attorneys who were supporting water protectors at Standing Rock. They literally had a legal tent like in the encampment at Standing Rock, and they continued that legacy of work defending land and water protectors across the country. And I always encourage people, if you believe in this work and want to contribute to it, to support their work. So I will leave you all with a song that was gifted to me by a relative during my time at line 3 here. I am the river, I am the sea, I am the salmon, the wild osprey. I am the wind in the aspen tree. I am you and you are me. And with that, I will open for questions.
I want to offer a question from an audience member online who says, what is your experience in the field of protest training, which helps protect protesters from criminal charges? I know of at least one organization that provides this training, but I wonder if there are more out there. And we refer to the national lawyers. So, you know, we can think of others, but that's yeah.
Thank you. I appreciate that question. I have not been responsible for organizing any protest training. I have some wonderful friends and colleagues and comrades who work more in the area of criminal defense and kind of specialize in working with activists and protesters in that space. So I have definitely participated in trainings largely through the National Lawyers Guild. Sometimes if there's a particular action that you're interested in assisting with, sometimes the organizations that are coordinating those actions will have their own trainings before something happens as well, or before an action occurs. So I always recommend, if you're interested in participating, to go to those trainings that are sponsored by local organizations or whoever's asking you to show up. But other than that, I think the National Lawyers Guild is a great resource.
So there's a question here that's at a more meta level, which is, how effective is lobbying versus litigation in achieving environmental justice goals?
I really think you need both, and it's very, people always hate lawyers just saying it depends, but it depends on the situation. I think in my practice, I have been engaging with clients in both concurrently. I think litigation can be used to apply pressure to lobbying negotiations, and alternatively, lobbying can create pathways to solutions that maybe aren't achievable through litigation, for example. So I really think that it's important for lawyers to work with lobbyists. I've had the pleasure of working with like legislative attorneys, also who, just have incredible expertise in navigating some of those policy spaces as well. But I would really encourage, again, a holistic look at what can be effective, because I think it really just depends on your relationships with decision makers and the political climate, and also the climate of our court systems have changed dramatically also, given just like the appointments made in our last presidency. So many of the federal courts just are not in places like the Ninth Circuit, which used to be pretty reliably liberal leaning, that's not true at all anymore. So I think we're in a space now where many lawyers are, really changing strategies and wanting to keep important cases out of federal court. That because of the risk.
Yeah.
So,
a couple more questions here. One is, how do you become a legal observer?
Great question. Again, I feel like I'm not sponsored by the National Lawyers Guild, but the National Lawyers Guild hosts a lot of legal observer trainings. Usually their local chapters will be responsible for organizing kind of on the ground legal observer trainings. Sometimes it's in anticipation of some kind of upcoming protests, but usually they have a couple per year. And I think that you can complete them online and virtually as well. So I would definitely check that out.
I just was thinking about when you're talking about the community lawyering, and I can see where that becomes self-sustaining as one community lawyer can train the next one.
Mm-hmm.
In the interim, I'm wondering if there's an agency that supports that, because obviously it changes your whole timeline, it changes your budget, it must change all of that. And I was just wondering where people look to for support, either to bring a lawyer to their community or for lawyers looking to get into that work.
Okay. That's a good question. I think community lawyering, there's not like a central organization or central hub necessarily for lawyers to identify as community lawyers. It tends to be a very individualized practice, I would say. It's definitely something that I've learned from some of my mentors, and I've kind of honed and refined based on, my own just intersectional identities, like as an Indigenous woman, bringing in some more like decolonial aspects to my practice. But you're absolutely right, it does change the timeline quite a bit, and I think that can be a bit of a challenge, but also an antidote to certain ideas of urgency that are present in the practice of law often. So it very much feels like an intentional choice and practice, and can sometimes be hard, especially like if you have, you can slow down all you want, but sometimes you have court deadlines and those don't slow down for anything. So it can be challenging. And I know that it is challenging for communities to procure legal assistance generally, but definitely to find and identify lawyers who identify with movement work. So it can be a challenge. I think if you can find a lawyer who is able to be on the ground with you, my clinic work can be challenging, right? Because we serve clients nationwide. I've really committed to doing as many site visits as we can in order to facilitate more of that like in-person relationship building. But being far away, it's challenging unless you're with an organization that like really is committed to traveling and doing those kind of site visits. So I think that's an exact answer, but thank you.
The definition of environmental justice that you had early on from the EPA was, I guess, so different from what I usually conceptualize as environmental justice, and that it seemed to be so much about procedure and the kind of like information access and this sort of stuff, as opposed to rights for the communities to not be disproportionately impacted. And are there more also like legal aspects in your work or in work of folks that you do work with that are also about using the legal system to try and stop the projects, not just in terms of protecting people from the criminal what do you call it, the accusations and the charges of criminality? Is it also what's the state of using laws these days in either federal or some of these states to try and stop projects?
That's a great question. So in clinic right now, we're representing a tribe that is opposing a proposed lithium mine in Nevada, which again is it's a complicated thing because the mine is largely being funded by funds from the Inflation Reduction Acts and the Department of Energy to facilitate our our transition to renewable energy. So it's a very complicated situation that we're finding ourselves in, that our clients are finding themselves in. But I think that the National Environmental Policy Act is still probably one of the most common federal laws. I mean, you have kind of all of the big environmental statutes that are still very much being used, like the Clean Water Act, I lived under before the Clean Air Act, Title V of the Clean Air Act, to address like larger petrochemical companies. Is still very active. The National Environmental Policy Act is tricky because it is kind of largely understood as, again, like a procedural law. It requires certain things of the industry before an action can be taken. It can be a really powerful tool of delay often. So to get back to the other question that asked whether it's better to engage in litigation or policy change, I think tools like NEPA can be really useful in delaying a project until there is some kind of political shift that can then give us a different solution, right? So it's often lawyers and our partners are engaged in this very like broadly thinking strategy around things like that. But it is in terms of mining and extractive industries, again, you don't see a lot of big wins where projects are stopped completely for tribes. I also represented a lot of tribal governments where you are suing because there was inadequate tribal consultation often as well. But I'd say you generally see more political wins. If you have wins under things like NEPA, it's often the court sending the industry back to redo certain documents like their environmental impact statements and things like that, but it doesn't necessarily stop the project. I think the wins more often come if the delay can be so great that it starts to impact the bottom line of the company, or there's some kind of like political shift that can then give us a different solution. But it's a tough area to work in.
This is a question that I think is building off of your comment about ALEC and the systematic ways that organization and others are trying to make it more difficult, right? Those criminalization laws. And so the question is, are you aware of any systematic efforts to push back against these new criminalization laws and ways one can support those efforts?
Unfortunately, I'm not aware of, if we're talking maybe nationwide, the same efforts to kind of address some of these laws. They are a bit newer. Still, there haven't been a lot of opportunities to see how they're going to be treated in court yet, because not many of them have been challenged. There was one challenged in Louisiana, but it was kind of missed on the procedural issue, so the court didn't actually get into the substance of like, is the substance of this critical infrastructure law constitutional? Does it create an unlawful restriction on speech? Like, courts haven't really considered that yet. So perhaps as time goes on and some of these challenges are made, we'll be able to see a path forward to a more organized resistance. But I think unfortunately, many extractive industries and political entities that support them have done a really good job of organizing in this way. So I think it would be great for those of us who are opposing extractive industries to pay attention to this and then continue to support organizing to oppose them as well. But I would say, check out the work of the Water Protector Legal Collective as well. Right now, they are an intervener in a SLAP suit that was initiated by Energy Transfer Partners, which is the company behind the Dakota Access Pipeline. So SLAP suits are again usually ways that corporations with a lot of money just bring a lot of kind of fraudulent charges against either individuals or smaller organizations just as a way to kind of harass and punish them. So they are currently engaged in defending against some of that work. So I would say, look into their work. There are other legal organizations that can specialize in slap suit defense and things like that. So perhaps check out their work as well.
Mia, thank you for your time today. This has been just a wonderful way to close out this day. I'm struck by your poem, your closing poem here. I'm the river, I am the sea, I am the sand. It's great. It seems to me that the definition of environmental justice that we saw from the EPA was so very limited. But even some of the other definitions of environmental justice are very humanistic. It's not, I am the river, I am the sea. And you also mentioned timing things, how maybe there's some social change, a political pressure that happens that moves us in some direction that allows then something kind of a social tipping point, if you will, to push something through. And I'm wondering if you could talk a little bit about this mindset, the difference of your thank you poem that you've closed with, and then the more humanistic focus in environmental justice, and how we shift mindset to get a social tipping point so that there can be more of that political action. If you're seeing how I'm trying to tie that together, yeah.
So I'm sure some of you are familiar with like traditional ecological knowledge, and I teach my students, again, because this work is difficult and you don't always see changes necessarily in your lifetime. Perhaps some of you have heard about the concept of the 7 generations time frame, right? Which is Indigenous people understand not just time going backward in connection to our ancestry, like starting again with the footprints that I showed you at the beginning, but thinking forward 7 generations, right? And understanding that the work that we do today, we're doing it for the next 7 generations, not just for us. So there are changes and results of the work that we do in this life that we may not live to see or benefit from, but we're doing that work for our descendants, right? And for our connection to the world and those who are going to live after us. So I don't know, it's sometimes hard to hold that time scale. It's hard to imagine what the world could look like in 7 generations. A little scary to think about the possibilities of what it could look like in 7 generations. But Indigenous people have already survived a world-ending event, and I think that there is a lot of wisdom and resilience to be taken from the experiences of people who have survived in that way. And we were just discussing like geoengineering earlier today, and just like how so little is still understood about the world and our connection and how everything is connected, and Creator made everything perfectly. I think it's a little, maybe going to the tangent now, but just a little presumptuous to think that we could perfectly recreate something that has taken a millennia or more time to perfect, So I do think that there is increasing understanding of the interconnections between us and our plant and animal relatives, and our place in the world, as we're going to live in this time of increasing climate disasters. I'm sure you all, like I am, and just my heart and thoughts are just so much with the people of Appalachia right now and all of the victims of the Hurricane Helene flooding. But I think as we move into this future of climate change, it's going to become more and more imperative to understand that connection. So I'm still hopeful.
This is going back to cases of terrorism and states who engage in civil disobedience. And the question is there a general argument that tends to in those cases to protect those people who engaged in civil disobedience? And if not, what are some of the ways that these kinds of cases have been?
So I will put a huge disclaimer that I am not a criminal law attorney. But I know that generally, because criminal law is so based on very specific elements of, things that the prosecutor is trying to show occurred, for example, that, introducing a defense of, well, this person's sentence should be lessened, or they shouldn't be considered guilty in the same way because the elements were met in the context of civil disobedience, doesn't so far tend to be super persuasive, I think, in court, because it's like if these elements are met, then someone is guilty, right? So I think the benefit of developing new jurisprudence that kind of recognizes civil disobedience as something that might have extended protections under the First Amendment would allow people to make more arguments and defend themselves using that line of reasoning. But right now, it's not something that I think would be very successful.
First Amendment, geez.
Yeah, yeah, exactly. Penumbra, the lawyers love to talk about penumbras.
I just have I'm kind of a loud speaker. The question around sovereignty and how that factors in. I know there's pushback both within the Indigenous communities on the use of sovereignty as a Western concept, but operating within that structure in the US, I'm curious on how that plays into Indigenous and environmental rights.
Something that I always like to put forward in discussing Indigenous environmental justice in particular is that the exercise of sovereignty is a really important aspect of environmental justice for Indigenous communities, and sometimes that might look like developing resources, right, so that they can provide economic growth and opportunities for their communities. So I think one of the reasons that tribes and, for example, the environmental movement or environmental groups, they have not historically been allies. It's only been actually very recently, I'd say the last 10-20 years, that you've seen more partnerships between tribes and environmental organizations. And I always put forward in the environmental law space that at the end of the day, for environmental law advocates, you really have to decide, do you believe in tribal sovereignty or do you not? Do you think that you can occupy this space of paternalism and tell a tribe how best to utilize their resources? Tribes have been prevented from decision-making over their lands and resources for a very long time. So I think often some environmental groups still struggle when they see tribes making decisions about resource extraction that they think are maybe not in line with their idea of how an Indigenous person or Indigenous community should be behaving. But tribes, don't have big taxable land bases like other sovereigns do. So these types of economic enterprises are really important ways that they fund their governments, right, to provide benefits to their people. So I always start by saying that environmental justice for Indigenous communities doesn't just look like protecting tribes from disproportionate impacts from extractive industries, even though that's a huge element of it. It also looks like respecting the decisions of tribes and how they decide to utilize their resources. So I think sovereignty continues to be a big issue. A lot of my practice has been representing tribes and trying to get the federal government to consult and actually engage in its trust responsibility in the way that it is legally obligated to. And that's a huge part of my practice, because consultation is often treated as a box checking exercise rather instead of an actual government to government engagement. So it continues to be a huge issue.
I was thinking about Vancouver and the towers that one of the tribal groups is building up there, and how the people of Vancouver, the non-Indigenous people are against the Indigenous people using their land as they please, and they don't like the density and huge issue. This is their land. You said they could do what they want. So interesting concept of sovereignty there. But I was curious about, so there are so many box checking exercises within state and federal government, NEPA, 404 permits, a whole variety of things that don't prevent any development. They just enable it slowly. And is there any interest from the legal side in actually making those more effective programs so that people that are, I feel like a lot of people get out of undergrad, with the plan to do something good for the environment, and they go into a state environmental agency and all they do is enable that development because that's their job. Check the paperwork and approve the plan. Is there any interest in actually looking at how, it's very dull, it's very unsexy work, but would there be any success potentially in going after those laws that just, and that would kind of be under the radar and maybe not find as many attacks as, because, you're just changing some technical requirements. It's just a thought. I work on the boring side of development, so this is what I do.
Great. Well, I've done a lot of zoning law too, so I feel used there. But so, if you think about the political climate of the country at the time that a lot of our seminal environmental laws were passed, I find it really hard to imagine a future anytime soon where like that level of bipartisan cooperation could happen such that that type of updating or changes could be made. I think, our seminal environmental laws, I think at this point, I think that's a great aspiration to have, and definitely depending on, political climate, something that could definitely be useful in the future. It is really frustrating that even a lot of the suits like CERCLA, for example, that regulates Superfund sites, it has a citizen suit provision that theoretically allows people to bring lawsuits for violations of the statute, but in practice, it's very, very limited subset of conditions that would allow someone to bring suit under the statute. So yes, I definitely share your frustration with like we have all these environmental laws, but at the end of the day, it seems like many of them are structured around like permitting and procedure. So I think it's a great idea and something to keep in mind for a future where actual teeth could be given to some of these statutes. But I do, just at this time period, kind of struggle a little bit to imagine the political climate that could exist in order to actually make that happen.
And Mia, I just want to thank you so much for making the drive down here and for being with us for this colloquium. This has been really great, and I know the conversation will want to keep going. So thank you again.